Welcome to the April webinar. We will be discussing frequently asked questions about trademark. Before we begin, there are some ground rules. So to turn off your camera and your microphone, and as we go on, feel free to type your questions in the chat box, and there'll be a session or a time for question and answer after the presentation. People who attend the webinar are eligible to receive complimentary consultation to discuss how we can help your business succeed in 2024. And to book that complimentary consultation, you can type interested in the chat box or reach out to any of the team members. My name is Princess or Priya. I'm an associate counsel at Cardinal Counsel, and my co-speaker is Chiamaka Okere. She's also a trainee associate at Cardinal Counsel. So the topic, like I mentioned earlier, is frequently asked questions about trademark. Today we'll be diving into the commonly asked questions about trademark and providing valuable insights to help you navigate this aspects. So we'll be covering introduction to trademark, trademark essentials, and all about trademark. So the most frequently asked question is, what is a registered trademark? What's trademark? A registered trademark is a trademark that has been registered within an intellectual property office, which extends the level of legal protection against its infringement. While a trademark is any sign capable of distinguishing the goods or services of one company from those of the other or from another, a registered trademark is the trademark that has been registered, and this extends the level of legal protection against infringement. So a trademark is typically denoted with the TM symbol, which entrepreneurs can freely use to communicate their intentions to use a given trademark in commerce. So trademark is important for every business owner or startup. And as a result, this trademark TM symbol is typically used for trademarks that have not been registered yet and are typically undergoing the registration process at the given point in time. Another frequently asked question is, should I get a trademark when I start my business, or should I do it later? It is actually very important to file your trademark application as soon as possible. This will help your brand. Since your brand is protected from the date of filing, you gain priority rights over anyone who intends to register an identical or similar wordmark or logo in any given class or classes within your chosen jurisdiction. You can consider filing your initial application in a country where you have the biggest customer or consumer base and where you have the most sales, as the risk of your brand being copied is the highest and very frequent. Over time, if your funds allow you to do so, you can also expand your registration to more countries simply by filing a new application for each jurisdiction to which your business expands. It is necessary to file an individual application for each country where you wish to register a trademark, as every application is examined separately by the respective IP office. If there is an issue with any of the applications, you don't have to worry because it has no effect on the rest of them. Moving on to what is a service mark. A service mark is a type of unregistered trademark that's used in connection with services as opposed to physical products. It is denoted with the symbol SM, and it is used frequently more than the general TM symbol. So this service mark that's denoted with the symbol SM is, you can commonly find it in the US. And similar to the TM symbol, there are no legal guidelines restricting the usage of the service mark. Usually the symbol is used by entrepreneurs who wish to signal that they are currently in the process of registering the trademark, which is an official and longer taking process, after which the TM or the SM symbol can be exchanged for the registered trademark symbol, which is the R. People also frequently ask what the purpose of a trademark is, like why should I trademark my brand or business? The purpose of a trademark is twofold. It will help signal a single source of good or consumer or services to the consumer, and it protects the brand. It protects the brand and giving their distinguishing characteristics from infringement, and improving customer trust or consumer trust. So preventing other companies from using similar elements in their branding when offering similar goods and services. So how does trademark protect your business? A registered trademark protects a brand from infringement by third parties in the countries where it is registered. The standard validity period is 10 years, after which the trademark can be renewed an unlimited number of times. Protecting from infringement others others are not only prevented from copying the elements of the trademark, but also using elements that give out a similar impression. And this is because the purpose of a trademark is to signal a single identifiable source of goods and services to the customer or consumer. Simply put, that a registered trademark protects the brand from competitors trying to profit off the customer's goodwill and the identity that the brand has built over the time. So practically speaking, a registered trademark gives its owners legal ground on which infringement can be prevented or stopped. And that's true using the R symbol with the name or the logo, which the trademark owner is only legally permitted to do after successful registration. This will serve as a signal to potential copycats that the business owners are not afraid to legally protect their operations and their brand, and to show that they can take necessary steps to enforce their rights. So it also includes having the right to challenge trademark applicants that are trying to register a similar trademark with the same intellectual property office. This act is known as or called raising an opposition. Another thing is the right to report the infringement on certain platforms, such as Amazon. The right to also issue cease and desist letters. So does a trademark have to be the same as my business name? It's okay for your trademark and your business name to differ. Trademark protection applies to brand names or logos or product name slash logos or slogans. So your company might be registered under one name, but the name of your brand might be different. It is also possible to own multiple brands under the same company with a trademark for each of them. You might also prefer not to tie the names together if you're in process of setting up your business, but you don't have the business name yet. So in that case, you can still register the trademark under your name and possibly transfer the ownership of the trademark later. Another frequently asked question is, can you trademark a person's name? Generally, you can trademark a person's name or surname, also known as an eponymous brand. However, some conditions must be met before you do so. The question of whether you can register one's name depends on the jurisdiction where you're planning your registration. For example, in Nigeria, a trademark can consist of a person's name, a personal name, and other signs such as letters, numbers, or colors, while in the US, the name you're planning to trademark must be unique and must be used in commerce, and registering the surname itself would also be examined particularly and strictly. So if you want to register your name simply to hinder anyone else from using it and you don't have a business, it's not possible. Um, when it comes to another question is the cost of trademark registration. When it comes to trademark registration, one of the most questions we get asked is what's the cost? And the cost of trademark registration actually depends on many factors, such as the choice of the country, the number of classes describing the industries the brand is active in, the cost of legal representation on top of the government fees, and the like of other factors that cover the cost of trademark registration. So it's very common to feel confused as to what the final price will be. So at this point, I will stop here while the second speaker would continue the rest of the slide. Thank you. Chiamaka.
Good afternoon, everybody. Am I as audible as I think I am?
Yes, you are.
Okay, good afternoon, everybody. My name is Shamaka Okere, and I am a training counsel, training associate at Cardinal Counsel. So I would be moving into the next question, which is, what is a generic refusal? Now, starting first, simply put, a generic refusal, when you hear the word generic refusal, it is a term it is when a person tries to register a term that is so commonly used in everyday language. And the whole essence of trademark is distinctiveness. From the explanations that Princess had given earlier on, you realize that the essence of having to trademark a brand, a product, or a service is to distinguish that brand or the product from every other company or every other brand or product, as the case may be. So when you register a trademark, when you're trying to apply for trademark registration and there is an issue of generic refusal, you just know that the term that you're trying to register is too common, it's too generic. That's what it refers to. It is too generic. So, for example, say you're trying to register chicken as your term for your products, and chicken is used by different restaurants, different brands. So it is a common term that any other person can use and does not necessarily distinguish you from any other brand or any other product. As such, because trademark laws is the core of trademark is based on the distinguishing factor of goods from every others. It is almost impossible to register a term that is so commonly used. The only way for you to escape generic refusal while trying to register your product is when, for example, you use descriptive terms rather. So we are saying that, for example, sharp television. Now the trademark is sharp, but now sharp is not something that you would necessarily use to remember that, oh, it's a television brand, for example. But now it describes the quality of the television in that sense of it. So yes, to avoid generic refusal, you have to ensure that you have a distinctive mark being registered as opposed to something that is so commonly used. The next question will be, can I file trademark applications by myself? So in some jurisdictions, it's very possible to register your trademark or apply for trademark by yourself. Nigeria is one of those jurisdictions where you can register your trademark yourself. So literally, all you just necessarily have to do is go to the registry, apply for trademark search, file the applications, they do all of the examinations and everything. However, it is usually advisable to have, in fact, even the registry would advise you to have a legal representative, a lawyer involved in your registration. And why is that the case? Because there are so many instances where while you're trying to register your trademark, you come around issues of opposition of your trademark. So say, for example, somebody comes up and say, oh, no, this is my trademark and you can't use it and everything around that angle. Because you don't have the required legal knowledge on how to tackle it, you would most likely be stranded. Or even when this case of generic refusal that I just mentioned, when you have issues of generic refusal coming up, how exactly do you intend to navigate around all of the complexities associated with trademark registration? So yes, of course, you can register your trademark yourself. However, it's very much advisable that you involve a lawyer while going through that. I'll be moving on to the next, which is, how long is trademark valid for? So in Nigeria, yeah, trademark is valid for an initial period of 7 years. So it is 7 years from the period of your application. Now, your question might be, oh, what's going to happen after the 7 years? You have to apply for a renewal. It's usually advisable to apply for a renewal in the space of the 12 months of the expiration of your trademark. So say, for example, your trademark, the 7 years would elapse in 2024. It's usually advisable that you do it within that period of 2024, say January, December period-ish. Do you get that? Is if that is the period within which you have registered your trademark. So within the 12 months of the expiration of your registration, it's usually advisable to renew your trademark at that point. However, if you're unable to do that, there is usually like a 6 month grace after the expiration for you to ensure that you renew your trademark. Now you might be saying that, oh, I have registered it, I have the full backing of the law and I have the exclusive rights to use this trademark and everything around that angle. So I have registered it once and then I can forget about it. If the 6 months elapses, what's going to happen to you? You have lost the protection. You have lost the protection that comes with a trademark registration. So you don't even have the rights to sue for infringement and everything around that angle because you have lost the protection. You can no longer enforce your rights. Like, it will be so difficult for you to enforce your rights. And another thing is that when that happens, you'd have to begin the registration process from the very beginning, like from the trademark search, from the very beginning, like how you do it in the first instance. So to save you the stress of having to start with re-registration or re-application, it is usually very advisable to ensure that you renew your trademark. And once you renew it after the 7 years, you have to continuously renew it after every 14 years. So it is an indefinite registration, and there is a period of time for each and every one of that renewal process you're going to go through. So yes, it is not a register once or apply once for everything. It is an apply once and continually renew your registration. So the next question would be, if someone's been using the name I'm trademarking for years, can they fight me for ownership? So generally, trademark ownership is determined by the first person to file for a trademark application. However, there are situations where a person who has been using a mark for a certain period of time may still have the rights, even if they haven't registered it. So you are the one going ahead to register it, but somebody has been using the name for a long time. Can they sue you for ownership? Yes, they can sue you for ownership. And that is part of the common law rights that exist. So in Nigeria, yeah, because of our colonial system, we have what they call common law and everything. But the main part of what I'm talking about is that you can establish trademark rights through common law usage. So businesses and individuals that have been using a mark in commerce for a significant period of time, they have enforceable rights with that mark. And so, yes, they can fight for ownership of the rights. And another way to bypass that might be what they call coexistence agreements. So if one person is not giving way for another, or if it is seemingly tight and then you have to go through litigation process and everything, the two parties can literally just come up, that the two parties that have the conflicting trademark can come together and enter into a coexistence agreement, and they're like, okay, so this is how I'm going to use the trademark, and this is how you are going to use the trademark. These are the areas I'm going to use the trademark, and those are the areas. So it is usually very advisable, like I said, to always have a lawyer involved during all of these processes. It saves you so much stress, and yes, the person can definitely fight for trademark ownership. The next would be that, do trademark apply across countries? Yes, trademark trademark does not apply across all countries. It is not a cross-country registration. The trademark is granted on territorial basis. So if you register your trademark in Nigeria, it is only applicable in Nigeria. If you register a trademark in the United States, it's only applicable in the United States. And that leads me to the next slide that says that, is it possible to own a trademark in multiple countries? In as much as trademark is territorial based, so we are saying you register in Nigeria, it only covers Nigeria. You register in Ghana, only covers Ghana. However, it is very possible to have a trademark in different countries. Now, there are certain ways you can go about that. You can go about it through the national trademark registration. So this means that if I want to also have my trademark protected in Ghana, I have to go to Ghana and then register it the same way I registered in Nigeria, through the registry, the trademark office of the country. That is another way. Another way you can do that is through regional registrations. So regional registrations is applicable, for example, in countries that are in the European Union. So if you register your trademark under the European Union trademark system, the unified trademark system, it means that all countries affiliated with the European Union, you have registered your trademark with all of those countries. So all of the countries that fall under the European Union, you don't have to go through national registration of each and every one of them. Through that regional registration, you have covered all of those countries. Yeah. Another is going through WIPO, that is World Intellectual Property Organization. That's way all of the countries that are a party to the agreements, the Madrid agreements. Then when you register through WIPO, you have covered your registration across all of these countries. And in other instances where there are bilateral agreements, say for example, 2, 3, 4 countries come together and they're like, oh, when you register here, it cuts across different countries at the same time. So that is the one for the bilateral agreement. Then lastly, seeking legal counsel and professional advice. So summary of key takeaways. First off, definition and importance. So trademark is a unique identifier for goods or services crucial for legal protection and brand recognition. What are the eligible things in trademark? So we have logos, name, slogans, and distinctive elements. All of this can be trademarked if they meet distinctiveness and non-generic criteria. The next is registration and maintenance. So registering a trademark provides exclusive rights with protection lasting indefinitely through proper maintenance and renewal. As for enforcement and international protection, you have to take prompt action against infringements. You have to consider international registration for global protection. And you importantly have to consult a legal professional or team that specializes in trademark for experts, guardians. If you have any question at this point, you can drop your questions in the chat box as we attend to them. And that'll be all from my end. Thank you so much.
We'll be having another session of this particular webinar in May. We hope that you join, because we hold this every month to share knowledge on trademark business and all of those things. So yeah, we've come to the end of this month's webinar. We'll meet you hopefully May next month. Yeah. Okay, bye everybody.